Passando à segunda palestra do seminário, convidamos para compor a mesa a ministra vice-presidente do Superior Tribunal Militar, que presidirá os trabalhos os trabalhos desta manhã, a doutora Maria Elizabeth Guimarães Teixeira Rosa. Convidamos também o palestrante Chief Judge James Baker. James Baker foi nomeado pela Corte de Apelações para as Forças Armadas em 19 de setembro do ano de 2000. A Corte de Apelações é composta por 5 juízes civis, nomeados pelo Presidente da República, com a recomendação e consentimento do Senado. Graduou-se em Direito pela Universidade de Yale, em Connecticut, no ano de 1990. Já atuou como assessor legislativo e como chefe de gabinete do senador Daniel Patrick Moynihan. Foi assessor jurídico do Conselho de Segurança Nacional, o NSC, de 1994 até o ano de 2000. É membro permanente do American Bar Association Standing Committee on Law and National Security. Baker ensina regularmente nas universidades de Direito de Iowa e Georgetown e já lecionou nas universidades de Direito de Yale e de Pittsburgh. A sua palestra tem como tema os 6 CS, o porquê, o quê e talvez o se é necessária para a justiça militar do século XXI. Senhoras e senhores, com vocês, James Baker.
As you can see, my Portuguese translation of my slides is being translated at this moment. It will come up here in a minute. I'd like to start by, is there some chance we could get the Portuguese translation up? While we're working on that problem, I'd like to start by, of course, recognizing the distinguished members of the judiciary in the room. It's a great pleasure to be here. I'd particularly like to recognize Madam Vice President of the Superior Military Court. I appreciate her invitation to come down here and continue a conversation we started in Washington about a year ago. It was a conversation that was built upon common bonds of law and common bonds of friendship. And so I was eager and leapt at the opportunity to come down, especially since she assured me it'd be a small meeting of a few people around a table. Not quite what I imagined. I'm also reminded that today is November 11th, which of course is Veterans Day in the United States, Armistice Day and Remembrance Day throughout the world, and I would be remiss without taking note of it. I think of 2 things today sitting here as I realized it was Veterans Day. First, I was reminded I was reminded, of course, of the common bonds and alliance during the Second World War between the United States and Brazil, which I think of when I think of Armistice Day and Veterans Day in Brasilia. I was also reminded of something General Omar Bradley said 60 years ago today on Veterans Day. General Bradley, of course, was one of the United States' most distinguished generals in history. And he presented to an audience of veterans the essential link between security and liberty. He said, to defend democracy against attack, men, and I would add women, must value freedom. And to value freedom, they must benefit from it. And that's, in part, one of the essential missions of a military court of justice, is to make sure that members of the military benefit from freedom as well as provide for our security. Now, while we wait on the slides to pop up, well, I'll give you my English version. This is my outline in my presentation today. Of course, I'll start by telling you that I asked my law clerks if they could find for me a picture of the Supreme Military Tribunal. And here it is, right? Is this not you out there? I think I recognize, this is you right here, right? So this is about where my slides are going to go when you get them. But here's my outline. I want to talk to you what I call the 6 C's, the 6 C's of military justice. And it turns out, courtesy of the creativity of Enrique and a few others, that my 6 C's, in fact, translate successfully into Portuguese as 6 C's. Here they are. You may or may not be able to understand them at this time, but you will in a moment. I'll read them to you. Context, credibility, civilian control, clarity, command responsibility, and counsel. And it's my proposition that any military justice system, wherever it may be, has to successfully address these 6 elements in order to be a viable and credible military justice system. First, some background. You heard a little bit of it during the introduction. I do want to give you a little bit of my background just so you know who's speaking to you, and you can figure out what bias I bring to you, if any. And I've also provided a brief outline of where our court sits in the United States. First, on my background, by the way, who would guess which is the most important legal training I had? If that's my essential biography, you can't read it perhaps because you don't have the translated version yet. But what do you think was the most important legal training I ever had? Was it Yale Law School? Not a chance. Best legal training I ever had was serving as an infantry officer in the United States Marine Corps. I like to joke that it's because I got yelled a lot, yelled at all the time. Lawyers get yelled at all the time. So I was well trained as a lawyer. But it was also because as an infantry officer, and this could be true if you were a logistics officer or a supply officer, you have the opportunity to make lots of decisions for which you're held accountable. And that's all about the practice of law. Now, as you can see on this excellent slide of our court at night, here we go. Our court sits here. And in our system of military justice, we have a 4 layers, really 3, but 4 layers of courts involved. The trial court is the court-martial, convened on a specific basis by each service. Then appeal of right can be taken to an intermediate appellate court. There is one for each service. There is one for each service, as you can see. And from each of those courts, appeal can be taken to our court, which is comprised of 5 civilian judges. We must be civilian, and from our court, appeal can be taken to the Supreme Court of the United States. In the 14 years that I have sat on our court, the Supreme Court has heard 1 case. So as a practical matter, for most cases, the final appeal is to the Service Court of Appeal, and then in certain cases, a final appeal may come to our court. That's the introductory comments. Here's the first of my 6 C's, and that is context. I believe and I speak here only for myself, of course, as a judge, I believe that there are many different ways to categorize military justice systems, and there can be a tendency to pick one system and say, they've got it right. Everybody else should do that. But I believe that each system must be designed for the context in which it's going to serve. And as you can see in your translation, that includes the historical and national antecedent, the nature of the missions that your particular military will engage in, the necessity or lack of necessity to deploy, and of course the size of the military. A credible and viable military justice system should be designed for the particular country involved. I have chosen to consider a number of factors I believe distinguish any credible military justice system, and we'll focus on those. Here we'll just show you in context what I mean. These are deployed cases for the United States Army coming out of Iraq and Afghanistan for the years 2003 to 2012. Not every military justice system needs to be deployed overseas. This is a justice system that might work for the United States. I thought it would be interesting for you to see how many courts-martial took place in Iraq or Afghanistan, and as you'll see on the right, also the primary offenses. And by the way, don't worry about taking notes on these. This packet is in your slide set. These are some of the in-theater cases that have come to our court on important questions of law. You can look through these. I will not be giving an exam on these at the end of the session. You can look at these citations at your leisure some other time, but it will give you a sense of the type of legal issues that our court has looked at arising from combat context. So context involves whether you're a deployed military or not. Context also has to take into account the volume of courts-martial. Our system of 3 layers of appeal doesn't make much sense if you're New Zealand and you do 10 courts-martial a year. That's a lot of judges doing a lot of work for 10 courts-martial. In the US context, where there were, when I started on our court, almost 5,000 qualifying courts-martial a year, and now about half that number, it makes more sense to have more layers of appeal to handle the volume. And this is an incomplete slide. The complete slide is up here, if you could all quickly read that. Good luck. But this is a slide in progress, and what it's supposed to indicate is each country may have a different number of JAGs, judge advocates, a different size of military, and a different number of courts-martial. And in the more complete slide, you'll see they quite vary. Therefore, you cannot just apply one model to every country. Point made. My second C of the 6 C's is credibility. In order for a system to survive and excel, it must be credible to its core constituencies. It must be credible to the military leadership, the enlisted ranks, the political branches, which in our case and your case would be the executive branch and the legislature, and it must be credible to the public, which after all is furnishing their young men and women to serve in the military. As I hope and think we all can agree, 2 of the essential elements for a credible military justice system would include an independent judiciary and an impartial judiciary. And here I've indicated a number of the aspects that might help a nation provide for an independent judiciary and an impartial judiciary. And if you can ask about it if you would like during Q&A, because each of those sub-bullets has a whole nother lecture prepared for it. Why should the public and commanders care that the military justice system is credible? This is an essential point. First, a credible military justice system helps provide support for the military as an institution. It can help provide support in operational context. If you have a military that is viewed as disciplined and held accountable, then the local populace in a counterinsurgency, in all likelihood, is more likely to share information and feel more comfortable around your military. If there is strong public support for the military as an institution, that will have budgetary consequences as well. A credible military justice system also will address recruiting. In the United States, for example, recent stories and issues involving sexual assault in the military, there is some indication, but not direct empirical evidence, that has had an impact on recruitment. A credible military justice system also adds to the morale and welfare of the persons who are subject to it, and it provides for legislative capacity. What do I mean by that? I think this is an important point. If the legislative branch does not understand the military justice system or does not believe in it as a viable and credible system, it makes it more difficult for the military or civilian leadership of the military to seek legislative amendment, maybe essential legislative amendment, because there is concern that if you ask for an amendment on one matter, you might get something back that you do not want. And a number of military justice systems around the world are in need of legislative update, perhaps including the United States. But if the system is not viewed as credible and viable, it's risky to open up that debate. Finally, as to why the public and commanders should care, a legitimate and credible military justice system is important in our international and coalition partnerships. It's clear that that is important in deployed context in Afghanistan. It's clear that that's important if you're arguing matters of complementarity in the International Criminal Court. And I think it would be important in Brazil's context that the military justice system, a system of discipline, is viewed as credible as we head toward the World Cup and the Summer Olympics. A credible system backs up a coalition's desire to share information and to work in alliance. My third C is civilian control of the military. I have put up here the essential constitutional provisions in the United States Constitution. You can compare for yourself how Article 2, Section 2 of the U.S. Constitution, for example, compares to Article 84 or Article 142 of the Brazilian Constitution. And as you see here as well, civilian control from the political branches is both a matter of the President and the Congress. I'd now like to make a few comments about the military, the civilian control of the military, with particular focus on the President in our context as Commander-in-Chief, and in your context, exercising the authorities of Article 84. First, as we all know, the President serves as the Commander-in-Chief of the Armed Forces. This is generally understood, and this is a depiction of the United States operational military chain of command. So, command is one of the essential elements of civilian control of the military. Point number 2. Civilian control of the military is also a principle found elsewhere. I mentioned that our court is comprised of 5 civilian judges. You cannot serve on our court if you have retired from the military or you serve in the military. The theory there is that we are providing civilian oversight of the military justice system. Now, as is quite evident, you have a very different model. That takes us back to context. It does not mean one model is better than the other. One has to look at the context, mission, and purpose to decide what model works best, provided there is an impartial judiciary and an independent judiciary. But civilian control of the military, in our practice, is also a judicial concept and a legislative concept. And it happens to be reflected as well in Article 88 of the Uniform Code of Military Justice, which deals with being disrespectful to that civilian chain of command. And down here in the right box are some of the famous cases of, and there are only a few of them, by the way, of military members who were found to be disrespectful. One military member called Abraham Lincoln a thief and was court-martialed. Can you imagine? Today we call each other that as acts of friendship. But back then that was viewed as a criminal offense. Okay, next observation. The concept, and I've made this point, the concept is broader than command. It also involves the selection of commanders as well as the relief of commanders. You have that in Article 84 as well. It's exercised in a different way. And my point in my message is not to say that civilian leaderships always make good picks or always make bad picks. But I do think one has to be careful not to get carried away and say generally presidents don't know what they're doing in our context. Think of President Lincoln down there in the left and where we would have been during the Civil War if not for President Lincoln firing and hiring ultimately the right generals. Think about where we would have been if President Truman, where you might have been as well, if President Truman hadn't fired General MacArthur, who was threatening nuclear war with China. So, civilian control of the military involves command, the hiring or the appointment and firing of generals as need be. I believe it also can bolster morale and welfare. An armed force that feels it has a connection to the public at large will feel it's on more solid ground. And there are also good national security reasons to favor civilian control of the military. In United States practice, it helps the military know that it operates at the full extent of its authority. We call this the Youngstown Principle after a particular case. But the idea is that when the president operates and uses the military instrument with the support of the Congress as well, the military will act at the zenith of its authority. We tend to think that means the president acts at the zenith of its authority, but that's true of the military as well. And where the law is clear and clearly invoked, militaries will take greater risk in the field. And I have to admit, though, this is really just an excuse to put one of my favorite slides up. Can you see who's parachuting on the right? How many of you have seen a dog parachute before? That's a dog with an oxygen mask, jumping, no doubt voluntarily, from, from 10,000 feet. He must be a Marine using the same old Marine method of volunteering. And civilian control of the military also can support help sustain unpopular or enduring operations. We know that well from Afghanistan. And a point I've already made, but I think it bears emphasis. Often one gets better results when the civilian leadership works hand in hand with the military. And in the United States context, I think of two immediate examples, both involving President Truman and General Bradley, who I referred to earlier. It was the civilian leadership, for example, not the military leadership, that desegregated the armed forces of the United States. And on the top left there, can anybody venture a guess who that is? If you can identify that person, I will dismiss you from taking the exam at the close of the presentation. I'll give you a hint. As a second lieutenant, he was court-martialed and acquitted. It was a racist court-martial. It was based on his race and not on his conduct. I'll give you a second hint. Do you know? Are you going for the credit? Absolutely. That's Second Lieutenant Jackie Robinson, one of the greatest Americans of all time and certainly a baseball hero. Okay. All right, we're having a little sidebar here for a second. If you all could go over there for a moment, we're going to talk baseball. But that's Jackie Robinson, a great American hero, and he was also the beneficiary of President Truman's desegregation order. And interestingly enough, he had been court-martialed. And I already made the observation about President Truman firing General MacArthur, which I think was one of the most important events in U.S. constitutional history, period. Okay, C number four, clarity. Clarity. By clarity, I mean a couple of things. First, clarity in jurisdiction. A military justice system that clearly addresses whether and when civilians are subject to the system will be a more credible system. Now, of course, it's important that you believe in the result as well, but it can't be a pick and choose jurisdiction. It has to be clear. Clear responsibility and accountability are essential to a credible system, and clear decision making. And by that I mean transparent decision making. Opinions are open and in public. They're put on the internet. They're available to counsel. I also think clarity comes from understanding the theory of the law. And by theory of the law, and this is important for all the lawyers in the room, I mean explaining not what the law is, but why the law is. And in the United States, for example, we're having a debate. I'm not having a debate because I'm a judge and I take the jurisdiction as it comes. But the Congress and the executive branch is having a debate over the role of the commander and whether commanders should have clemency authority. What the law is Article 60. And Article 60 provides that commanders can exercise clemency over findings and sentences. The theory, though, is why? Why does a commander have clemency authority? Until you understand that, you can't really engage in a debate over whether commanders should have this authority and when. Therefore, it's essential for the lawyer, the judge, or the commander to not only say what he or she is doing, but why. So, for example, clemency is an essential check on the power of the state when it overreaches. And it is an inherent nature of national security that national security specialists will overreach. That's part of what happens with national security. Clemency is a mechanism, not the sole mechanism, by which the system can right a wrong. And in the middle there, I have an example. That's Lieutenant Flipper. And it's not from the television show in the 60s. Lieutenant Flipper was an African-American officer, the first African-American officer to graduate from West Point. And he served in the West, in what we refer to as the American Indian Wars or Native American Wars. And he was court-martialed largely or almost exclusively because he was black. It was not until 1997 that the President of the United States, as Commander-in-Chief, and using his pardon power, pardoned Lieutenant Flipper and erased the conviction. Now, it didn't do Lieutenant Flipper a lot of good. He was long dead. But that's an example of the pardon power or the clemency power being used to right a wrong. Clemency in a more specific context also allows a commander to make a judgment in context whether they would rather have Lance Corporal Baker in the brig or on the front line in the context of an ongoing conflict. And the question then becomes, should clemency be available if I've committed a serious offense, rape, murder, and so on, or only if I've committed a misdemeanor offense that warranted non-judicial punishment? So there's room for debate here, but the essential thing is that clarity comes from understanding why the law is, not just what it is. I mentioned civilian jurisdiction. Many different military justice systems approach this in different ways. My message here, although I have a view, my message is not that one type of jurisdiction is the correct answer, but whatever it is, it ought to be clear. And the essential debates are over whether military jurisdiction should be limited to offenses for which there's a service connection, whether it should be location-based, i.e., that is, only on a military base, and so on, or should it be status-based? In the United States, military jurisdiction is status-based. That means if you are in the military and you commit an offense on or off base, on or off duty, against any state law, federal law, or military law, you are potentially subject to the Military Justice Code. That may not be the right answer in context, but it is a clear answer in the United States context. The military location one, not so clear. If you were in Egypt, for example, you would not know which parts of the capital had been declared military locations until you had been arrested. That's not transparency. Okay. Transparency also means, obviously, public trial, public knowledge of the law, and public knowledge of the decisions. We're all aided here by the internet in computer capacity, but this is something that warrants attention, and how it is debated in the United States arises in the context of whether appellate proceedings should be subject to televised viewing. I don't know, what is your practice? Do you allow cameras in at the Superior Military Tribunal? You do? Do you? Do you allow television broadcast of your... Oh, very interesting. So You're ahead of the game on transparency, aren't you? And I'll ask you how that goes later. Okay, my next C. Remember, there's 6, so if you're getting tired, you know you're coming here in the home stretch. The 5th C is any credible military justice system has to deal with, and deal with successfully, the role of command, the role of commanders, the role of the military leadership. And again, speaking only for myself, I'll make a couple of points here, which is I personally believe, although I apply the law that is passed, that military leaders and commanders are central and essential to any military justice system. This is not the same thing as saying they should or should not exercise clemency authority. But military leaders, commanders, define the culture of any unit. And military leaders are the ones who live most directly with the existence or lack of existence of good order and discipline. And oh, by the way, if you are relying on the investigation of an offense or to get access to a witness, it's not the lawyer who's going to do that, it's the command who will provide that access. So they are an essential player. The question is, how do we make them a successful player? Here is General MacArthur's quote, and you might note that I'm not a big General MacArthur fan, not a MacArthur fan at all, for all the reasons I identified with President Truman, but he had this bit right, which is a military that is not controlled by discipline and military justice is nothing more than a mob. You can read and study that on your own time. The other thing a credible military justice system has to do with command is make sure that there is not what we call unlawful command influence or undue command influence. This is reflected in the cartoon, and it's reflected in the attitude that the command will get what it wants from a court-martial or from non-judicial punishment. You wonder who that person is walking off into the Alaska wilderness? That's my father. Not really, but he was told when he was a paratrooper, he was called into the office and he was told to serve as defense counsel for a soldier accused of a crime. He represented the soldier, and my father was not a lawyer, he was just a paratrooper on duty. And he defended the guy and he got off. And my father was going off to be an aide-de-camp to General Stilwell Jr. They changed his orders and sent him to Alaska as his reward for successfully defending someone. Now that's undue command influence, right? That's unlawful command influence. The orders were changed, by the way, so the system righted itself. A command and credible military justice system also has to guard against command impunity, right? The command has to be capable, or at least capable of passing off to someone else, investigation of its own conduct. In the United States, the most profound and disturbing example of this, of course, is the My Lai incident from Vietnam. The command did not investigate itself. They did a bogus investigation, and it was only years later when soldiers came home and reported post-traumatic stress from the incident that the military went back and reinvestigated the events in My Lai, reflected here by General Piers, who led that investigation in the classic cigar-chomping way. Appearance against impunity also means that officers are treated in a similar manner to enlisted soldiers. Here are a couple of famous officers who've been court-martialed in the United States system, and you can make your own judgment as to whether it was deserved. I say that with respect to George Custer over there. He was a court-martialed, but so was Bull Halsey. one of the great admirals of World War II, who lived to fight another day after his court-martial. And these are just different ways that in US law, the concern and risk of command impunity has been addressed. And I also make reference here to a couple of the European cases and a Canadian case with the same intent. My point here is not to now spend time talking about these, but to give them to you as a reference that you can look at a later day and think about different mechanisms that guard against both unlawful command influence and command impunity. Okay, the sixth and final of my 6 C's is a credible and viable and sustainable military justice system has to have a professional defense bar, a professional trial bar. It has to have great lawyers. I think one of the fundamental strengths of the US military justice system is the fact that lawyers, judge advocates, are furnished free of cost to both sides at the table. Defense counsel is provided free of charge all the way to the Supreme Court, and of course, trial counsel is as well. It is the lawyers with their competence, but as importantly, their conscience, that are the backbone to any great and credible military justice system. So if I were looking at context and credibility, I would look very carefully at how we train lawyers that appear before military courts, who they are, where they come from, and what ethics they're taught. What ethics they're taught. The way I teach ethics is largely through talking about the role models that have been most influential to me as legal role models. And on that list, I have my mother, who is not a lawyer, and that would be odd if you had my mother as your role model. But how about Nelson Mandela as a legal role model? You can't do much better than that, and he's on my list. As is Frank Johnson and Elbert Tuttle, who were 2 of the great civil rights judges of the civil rights era. That leads me to my conclusion slide here, which shows the soccer player passing out after making it the distance. Randomly picked some random team. I'm not sure what teams these guys represent. But I do know that when I was a kid in 5th grade, before you could watch soccer on television, we used to pass around a film that we would take. You'd go from player to player on the team, and we'd take a film and the projector of Pelé films. And it was the lucky week when you were the kid who got to have the week with the Pelé film. But that's not quite about military justice, but that does give you, get us to the conclusion point. I don't know if we're allowed to do questions and answers or whether you prefer to go on to lunch, but thank you very much for your attention. Sure, I'm happy to. Thank you. Oh, okay, fair enough.
Pedimos preferencialmente alguma pergunta por escrito, se tivermos, que passe para a nossa equipe de cerimonial.
A pergunta é da doutora Maria Placidina Araújo, nossa juíza auditora. Como ocorre a escolha dos nomes que ocuparão os 5 cargos da Corte de Apelação das Forças Armadas? Eles gozam da garantia da vitaliciedade?
Thank you very much for the question. It's a very good question, and as I like to say, an appellate court is a wonderful place to study what pure oligarchy would look like. Because on any appellate court, every judge is created equal. We have had debates, and I'll get in trouble with my colleagues about this. We have had debates about things like who will walk through the door first, because everyone is equal. And fortunately, we figured out the seniority thing, so we don't spend quite as much time about door walking. But what it means is there's 5 different answers to every question. And here's the link to the question I was asked. There are 5 different ways that each of the judges on our court today came to the court. I can do 2 things. First, tell you how I came to the court. And second, tell you that as a general matter, the one essential ingredient is that you have to be nominated by the President of the United States and confirmed by the Senate of the United States. So the correct answer to the question is, how do you get your name on the President's desk? Now, in my own case, I happen to work as a career civil servant as the President's national security lawyer. What I did not realize was that there is a normative process of selection and an actual process. The normative process in our country is that the DoD, the Department of Defense General Counsel, when there's a vacancy, will ask for recommendations and will present those recommendations to the Secretary of Defense, who will present them to the President. I went through that process because I believe in normative process. Of course, everybody else went directly to the President because that's what matters. In the end, I was lucky enough to be selected because I was someone that was known to the President, and I was supported by the Secretary of Defense, the Attorney General, the National Security Advisor, and the Counsel to the President. But I was not a political person, so I had no political support. And you would think that might be a good thing, and certainly a good thing for any court to have people who are non-political appointed, but it also means no one supports you in Congress. It was at that point that the Marine Corps, thank you very much, we were talking about this, was very helpful in letting everybody know that I was the Marine candidate. Of course, there is no such thing. Now, in terms of diversity, one of the strengths of our court, I believe any court, and this is the strength of your court, is we don't have 5 judges on our court because our workload can only be performed by that number of people. We are a redundant court. It's 5 different people doing the exact same task on every single case. That's not a great model if you're trying to save money. But what it does mean is that there are 5 different views and perspectives being applied to each case, which is an important source of diversity. We have not had, our court has been around since 1951. There have been 2 African Americans who've served on the court and 2 women. Not very impressive. But I will say, one of the great judges in United States history served on our court, Matthew Perry. And Matthew Perry was an African-American lawyer during the Civil Rights era who used to appear in court in South Carolina by passing notes to a white lawyer who would go down and appear before the judge because he was not allowed to appear before the judge himself. And Matthew Perry was the first African-American judge to be appointed to any federal court, district court in the United States. And he started on our court and then went to the South Carolina Federal District Court in Columbia. The courthouse is now named for him. So that is a form of diversity. Again, the first part of the answer, if you don't like the membership of the court, go talk to the president. Because I don't mean that in a fresh way. I mean that because ultimately it's the president who nominates someone and it's the Senate that confirms. Are there criteria? There is one negative criteria, which is you cannot have served, you cannot have retired from the armed forces, and you cannot be an active military officer, because it would defeat the concept of civilian oversight. I was a infantry officer at the time I was appointed to the court, and I resigned my commission because I wanted it to be very clear to each young enlisted person who came before the court that I was there as a civilian, not as a military officer. Is that responsive to the question? Oh, very interesting. Good, good. The side comment was that our two systems are very parallel in this regard.
For the Supreme Military Court. Mais alguma pergunta? General Sock, por favor.
Tenente General Gabriel Sock, juiz do Supremo Tribunal Militar de Angola. Eu quero, antes de tudo, agradecer o Superior Tribunal Militar Brasileiro, assim como o Ministério Público, que nos dignou convidar-nos para participarmos deste seminário, justamente hoje que estamos celebrando a festa da nossa independência. O normal seria um dia de lazer, mas temos que reconhecer que o Brasil foi o primeiro país a reconhecer a nossa independência e fizemos a gentileza de estar aqui para partilhar a alegria da nossa independência. Relativamente ao nosso palestrante, também temos que lhe parabenizar pela forma sábia e clarividente como trouxe os 6 S's para aqui, e isso começa a criar um interesse para levarmos os 6 S's para a África, para Angola, e se calhar teremos que fazer do Superior Tribunal Militar, C6, perdão, utilizaremos de certeza o Superior Tribunal Militar Brasileiro e o Ministério Público correspondente para fazermos essa ponte. As minhas inquietações são as seguintes. O senhor falou da credibilidade da justiça militar. E eu queria perguntar ao senhor se esta credibilidade não passa, acima de tudo, pela credibilidade das próprias Forças Armadas que essa justiça militar serve. Porque Forças Armadas moralizadas e que moralizam a sociedade, não há como se desacreditar ou descredibilizar as duas instituições tais como os tribunais. E o senhor falou da transparência. Eu queria saber também se a transparência não passa por uma assunção, por um exercício de autodivulgação, de promoção, porque o que ocorre é que esta é a doença da justiça militar, fecha-se. E então, isso causa interpretações às vezes erradas, causa, vamos assim dizer, eu quero partilhar a experiência do meu país, que quando surge, por exemplo, processos midiáticos, aí todo mundo quer falar, e infelizmente acaba por falar o que não deve falar, acaba a falar o que nunca aprendeu a falar, porque temos infelizmente esta doença de nos fecharmos. Eu acho que esse é o meu ponto de vista, queria saber se o senhor partilha, se esta credibilidade, esta clareza não passa também por um exercício de autodivulgação, de autopromoção, para que efetivamente a gente se explique quem somos e o que é que fazemos. E para terminar, eu gostaria de saber se a nível do seu país os civis podem responder pela justiça militar. Bom, nos slides que colocou, Não vi em nenhum momento nenhuma referência de um país africano, e eu quero deixar a nossa experiência. A credibilidade nossa passa tanto por uma postura legal que nós assumimos, que nosso país assumiu. Um país é sempre diferente de qualquer país, em função disso que o senhor falou, de que não há um modelo, vamos assim dizer, superior. Se calhar cada modelo se adapta à sua realidade. E então nós, para ser juiz militar, para ser procurador militar, é necessário a formação em direito. Nós, ao nível da nossa Suprema Corte Militar, somos todos oficiais generais, mas com a particularidade de que somos todos formados em direito. O Ministério Público Militar está integrado dentro da Procuradoria-Geral da República e também não será procurador militar se não é formado em direito. Então, isso, de alguma maneira, ajudou e ajuda a credibilizar o nosso sistema. Muito obrigado.
Well, thank you very much, Judge, for your questions and comments. I will make 5 observations in response. You spoke about the credibility of the armed forces being as important, if not more important, than the credibility of the military justice system, that the two are linked. I don't know if you have the phrase the chicken and the egg or the cart and the horse. These are legal terms. But I am using these legal terms for the proposition that I couldn't agree more, that the reputation and credibility of the armed forces is going to be integral to the reputation and credibility of the military justice system. At the same time, if you don't have a credible military justice system, holding members of the military accountable for their conduct, you will be sure to have an armed force that is not credible to the country. So the two are linked. And the commander that does not understand that will fail as a commander and not set the right climate of military discipline and good order and discipline. In this regard, I might note that in our practice, the Uniform Code of Military Justice expressly states that it is intended to provide both for justice and for discipline. My next observation, and I may have this wrong, you commented on self-promotion. I would like to say that I think the primary duty of a judge, whether they are a military judge or a federal judge or a state judge, is to hear cases and do so with integrity and in obedience to the law. I also do believe that it is a secondary duty of any judge to teach, to tell others about the law, to explain the law, to talk about the theory of the law. And this is especially important for military judges, be they civilian or military, because so much of society does not understand what military justice is and why does it exist, at least in our country, as a separate system of justice. Who's going to explain that? A professor like Gene Fidel, who will speak to you, is going to explain that. And we are lucky that he is teaching military law at one of the great law schools in the United States. But it's also judges who are going to do that. And I'm not sure if that's self-promotion, but it is explaining the law to a larger audience. And I know I've met a few of your students, and I know you're participating in this theory. In the U.S., the judicial canons, our rules of conduct, expressly state that a judge may teach, and indeed should. 3 more points in shorter form. Since I can't read my handwriting, I'll skip this one, but it was a really good point. You noted that I did not have any African slides. I will tell you, sir, that some of my presentation, and I'm not going to mention this to you because you may get angry at me, some of my presentation was lifted from a presentation I made to African judges and military lawyers. And I would be happy to share that with you. Might I do so? And then finally, you did mention that judges on your court have to have law degrees. And I must say, with the previous question, I didn't note that that is a requirement on our court. You have to have a law degree. I assume that you would believe that, but it is true we are all lawyers on our court as well. That does not address all of your question. I hope it is the beginning of a conversation I will have with you and that you will have with Madam Vice President in the days, weeks, and years ahead on this very topic. Will you commit to that, sir? Okay, okay. Yes, of course.
Há uma terceira pergunta. Como funciona a aplicabilidade do habeas corpus perante a Corte de Apelação das Forças Armadas Americanas? Durante o decorrer processual, o réu militar permanece em liberdade no exercício pleno de suas funções ou é recolhido a uma organização militar ou penitenciária militar, ou presídio militar?
Thank you very much for that question, which is what we call a compound question, 2 questions in 1. The first question had to do with habeas corpus, known in our country as the Great Writ. U.S. courts, federal courts generally operate under something called the All Writs Act. And as the word all suggests, all the writs apply if the All Writs Act applies to your court. Now I'm going to summarize a very complex area of law into a simple answer, which is yes, habeas corpus applies to military courts. There's a complexity here because there are no standing trial courts in the United States military. The only standing courts are those courts of criminal appeal that each of the services have and our court. But I can tell you from firsthand practice that yes, we entertain and will entertain a writ of habeas corpus, provided that's the correct writ, and you are in fact in the detention of the government. There are also other writs that might apply, and I won't pretend I know Latin, but most of them have Latin phrases. And when we get one of those, I'll ask my clerks, what's that mean and what's your recommendation? So the answer is yes, the writs apply. There is the second question had to do with military detention and arrest. And if you will spare me 30 seconds of background. During the Civil War, have you all heard of Oliver Wendell Holmes?
Oh, Yes, very much
Okay,
indeed.
the correct answer is yes. Very good. Oliver Wendell Holmes fought his first engagement during the Civil War at the Battle of Ball's Bluff. It was a Union disaster. The Union forces were commanded by the only U.S. senator to die during the Civil War, Senator Baker. The problem with Senator Baker, I'm sorry to report, was he was a terrible commander. And he managed to lead the Union forces across the Potomac River and establish them on the edge of a cliff from which they could not maneuver. The Mississippi Regiment charged, and the Union forces were killed or captured. Senator Baker was killed. Oliver Wendell Holmes was wounded twice, but made it across the river alive. When my children at age 5 and 7 visited the battlefield, voluntarily, I might note, they immediately grasped the terrain. They said, "Why'd the Union soldiers go here?" And then they turned to me and they said, "We're not related to Senator Baker, are we?" Now you're saying, thank you for that terribly interesting story. What's it have to do with anything? The Union forces were so angry about this battle, they went and arrested the nearest general, General Stone. General Stone was not at the battle. He had no influence on its outcome. They locked him up for, I'm going to make this up because I can't remember, something like 164 days, without charges, without access to a lawyer, and so on. As a result of that, the Articles of War were changed to require such things as notifying the person who's been arrested why they've been arrested, and requiring an appearance before a judge within a certain amount of time. The short answer to the question, therefore, is yes. There is a pretrial process that occurs in the military where a military magistrate will determine whether someone qualifies for pretrial detention or not. And there are certain rules about pretrial detention, such as you can't be commingled with convicted soldiers. So you're presumed to be innocent still, even if you are a flight risk. And that's subject to our review as well. There are rules about no pretrial punishment, and we will often hear appeals about people who've been detained who will say, "I was punished before I was tried," and we will look at that question. And I'll make one final point with this question, on this question. The military prisons in the United States, there are only a few of them left, and the flagship, if you might call it, it sounds like a hotel, but it's not, the primary military prison for longer term detention over 5 years is Fort Leavenworth, Kansas. And there's a prison in Chesapeake, Virginia, a prison in Miramar, California. And I don't represent the prisons. I don't run them. I do inspect them. Judges in the United States are authorized to visit any federal prison. And I always visit prisons to make sure that they are clean, well-run, and safe. And the military prisons in the United States are clean, well-run, and safe. And I would encourage anybody in this audience to ask to visit one of those prisons. Now, you can say I told you to do so. That won't do you any good, but you can try. But I would encourage you to do so. because it does give you an example of how to run a prison. And if you are in prison at Fort Leavenworth, Kansas, and you are not behaving yourself, the commander can invite you to transfer to the local state prison. And lo and behold, you will begin behaving yourself because the prisoners know exactly which prison they want to be in because it's run with military discipline. Military discipline continues into the prison system. Anyway, thank you for the question and the opportunity to say that.